SRA 211, Session 3.4.1 Legal Aspects of Counterterrorism Policies, Part 1. We have cited law enforcement and legal measures as one of the many tools available to counterterrorism officials throughout the world. And that's going to be the subject of this session and the next. In this first session, we'll look at the issue of terrorism and international law, briefly examine the Geneva Conventions that deal with aspects of international law in warfare. We'll consider the philosophical issue of whether counterterrorism is an armed conflict or more like law enforcement. We'll then look at the controversial issue of targeted killings, and finally say a word or two about Guantanamo and the detainees there. The first question we need to consider is the extent to which international law should apply, if at all, to terrorism and counterterrorism efforts. As you may know, modern international legal principles developed really to deal with disputes between sovereign nations, not one nation or group of nations and an organization, such as a terrorist group. Today's international terrorists are largely what are called non-state actors. They are not legitimate recognized governments. In some cases they may have the backing of governments, but that's not the issue. In dealing with them, you are dealing with something that is not a country or not a state. Now, while there is precedent in history for applying international legal norms to non-state actors, such as one example would be, although it's not exactly on point, the treatment of the Barbary pirates in the first years of the 19th century. But even though there might have been some episodes in history where countries got involved with basically groups rather than countries, and the Barbary pirates in some ways really were representatives of states, so it's not exactly on point. But many international legal principles, especially those dealing with the laws of warfare, have proven to be a little bit inadequate with respect to terrorism. Some of the key issues or questions are, do the Geneva Conventions on the law of war, these were multilateral treaties worked out in the early part of the 20th century that regulated conduct of countries in warfare. Do these international agreements apply at all to international terrorists? In particular, should captured terrorists enjoy the same rights as prisoners of war? In those Geneva Conventions, there are clearly defined rights and limits on things you can do with and to prisoners of war who are captured on the battlefield. More broadly, can nations lawfully rely on the so-called inherent sovereign right of self-defense that's also been established in the United Nations? Can nations rely on this in responding to attacks from non-state actors, such as terrorist organizations? And I suppose the way you answer these questions is going to depend in large part on whether you consider counterterrorism operations to be an armed conflict, actual warfare, or something more like law enforcement, police work, or maybe something else. Here is what the United Nations thinks. In a Security Council resolution that was passed shortly after the 9/11 attacks, the United Nations underscored the need for states to ensure that any measure taken to combat terrorism comply with all of their obligations under international law, and that measures should be adopted in accordance with international human rights and humanitarian law. This has been reaffirmed in subsequent Security Council resolutions. So speaking on behalf of the United Nations, the group of countries that most of the countries of the world, this is the view of the United Nations as regards counterterrorism. But the UN statements really don't necessarily answer the question, because the question of applying laws to counterterrorism still depend on the fundamental philosophical issue of whether counterterrorism is war or law enforcement. This is very important because it has implications for the use of force, powers of arrest and detention, keeping people detained, and administering justice generally. Most importantly, in war, combatants are legally entitled to use lethal force against enemy combatants, including enemy leadership. Outside of a war context, there is no combatant's privilege. Police as well as military personnel who are acting as police officers in a law enforcement capacity, they're held to far stricter standards on the use and employment of lethal force. This question of whether counterterrorism is war or law enforcement is relevant to a number of sub-issues, including the practice of targeting individuals for assassination. As we're going to see, the United States, and as you may know, the United States has conducted targeted assassinations of terrorist leaders. Now, in the context of an armed conflict, of actual warfare, it is in fact legal to target officials who are in the chain of command, including senior leaders. The image depicted on the slide here is the operation to kill the Japanese Admiral Yamamoto, the architect of the attack on Pearl Harbor that precipitated the United States enter into World War II. The United States military obtained information that Yamamoto was going to be traveling in a two-plane convoy, lightly armed, to visit some troops. We knew where he was going to be and when, sent a squadron of fighter aircraft and basically shot him down and killed him. That was considered legitimate in the context of an armed conflict or warfare. And the United States, as you know, has employed this policy of targeted killing of leadership, enemy leadership, in the context of counterterrorism, by way of drones, UAVs, and so on. This has generated some controversy. These are, in fact, examples of targeted killings, which are defined as premeditated acts of lethal force employed by states in times of peace or during armed conflict to eliminate specific individuals outside their custody. Now you should note that since 1976, so-called peacetime assassinations have been officially banned in the United States. So on what basis do these drone strikes, the killings of people like Abu Musab al-Zarqawi with an airstrike and Osama bin Laden in a military operation, what is the basis then for these? Well, the basis goes back to some points we considered in an earlier session, the centerpiece of the U.S. strategy for counterterrorism, that, as you may recall, stated that the United States is at war with international terrorism. The United States considers itself to be in a state of armed conflict with Al-Qaeda and associated forces such as ISIS. The United States maintains that the U.S. right of self-defense, as set forth in Article 51 of the United Nations Charter, includes targeted killing of persons who are planning attacks, both in and outside of declared theaters of war. That's an interesting concept. A theater of war basically means the area of the planet where a war is being fought. In the context of the global war on terrorism, you tell me where the theater of war is. I would say it is the entire world. In addition to relying on Article 51 of the United Nations Charter, there's also a domestic legal basis for targeted killing of specific individuals. And it's the 2001 Authorization for the Use of Military Force Act. This law empowers the President to use all necessary and appropriate force, in pursuit of those responsible for terrorist attacks. This law itself has generated controversy. It's actually never been updated. There have been attempts to repeal it, but it is the legal underpinning for many of our efforts in the counterterrorism world and also for the targeted killings. As you might imagine, however, targeted killings are especially problematic when the target, the individual killed happens to be a U.S. citizen. There was in fact considerable controversy back in 2011 over the killing of an al-Qaeda terrorist, but also who happened to be a U.S. citizen, Anwar al-Awlaki. He was a citizen in the sense that he was born in New Mexico when his father was a grad student and therefore acquired U.S. citizenship. But as far as I know, he never lived in the United States beyond being a baby and really had no connection to the United States, but he technically was a U.S. citizen. And supposedly all U.S. citizens are entitled to due process of law, etc., etc. The White House at the time, the Obama White House, justified it. Former Attorney General Holder said the decision to kill a U.S. citizen abroad is among the gravest decisions that a government could take, but they justified the legal action as legal and necessary, saying there was a three-part test. The administration determined that the citizen, Awlaki in this case, posed an imminent threat of violent attack, that capture of this individual was not feasible. He was hiding, I believe, in Yemen, outside the reach, more or less, of U.S. Law enforcement authorities. And the third qualification was that the killing would be consistent with the laws of war. In other words, killing a leader of an enemy or organization or of the enemy in a time of warfare. In addition to targeting individual terrorists for killing, as you no doubt know, the United States has seized and detained a number of terrorists, primarily at the Guantanamo Bay facility, which is probably the best known. So what are the issues regarding detention? Again, it depends on whether or not a state of war exists. Under general human rights law principles worldwide, anyone arrested or detained on a criminal charge must be brought promptly before a judge or judicial officer and has the right to a trial within a reasonable time. Indefinite detention with no trial is considered arbitrary and a violation of international humanitarian law. In time of warfare, it gets a little less clear. The prohibition of arbitrary detention is interpreted in the context of a war so that captured enemy combatants may be detained and civilians of an occupied territory may be interned for the duration of the war. So is the war on terrorism over? No. Now, with respect to what are called privileged combatants, such as the regular forces of an opposing party, this is generally in times of war. The Third Geneva Convention governs their treatment as prisoners of war, and they're entitled to certain rights as prisoners of war. So you can see there's a little bit of different rules whether there's a state of war or not. So what is the status of captured terrorists? How do we view counterterrorism operations in terms of warfare, not warfare, prisoners of war, etc.? The United States view evolved. Prior to the 9/11 attacks, counterterrorism action by the United States really centered on law enforcement activities. The responses to the Pan Am 103 bombing, the first bombing of the World Trade Center that took place in the 1990s. Now, there were some exceptions. In 1986, in response to information that the government of Libya had sponsored an attack on a disco in Berlin, Germany, in which a U.S. service person was killed and a German woman, Ronald Reagan, the president at the time, ordered an airstrike in Libya. So there was resort to military force occasionally. That really changed in a big way in the post-9/11 environment. As we've seen, the United States now considers itself to be at war with international terrorism. There's much more focus on the rules of warfare than on law enforcement. And we've created sort of a new category to describe Al-Qaeda and ISIS fighters. They are considered something very important that the United States calls unlawful enemy combatants, not legitimate prisoners of war, unlawful enemy combatants. What do we mean by this term, which is a very important term for this course? Now, first of all, note it's not a traditional international law concept. It's sort of been devised by the United States. According to the law that established this category, these are people who have engaged in hostilities or purposefully and materially supported hostilities against the United States or its allies, or people who've been determined by a review tribunal or other competent trial court or tribunal as an unlawful enemy combatant. So basically, Al Qaeda and ISIS fighters are considered unlawful enemy combatants. They have certain rights, but the United States does not give them the full rights of either people investigated and arrested for criminal acts, or on the other hand, they do not get the same full scope of rights as prisoners of war. And they are the people, by and large, who were brought over time, and many stayed and many were released to the Guantanamo Bay facility. Now, not all of the unlawful enemy combatants were incarcerated in Guantanamo. Some were actually tried in federal court. Some were tried by military commissions. Some are still held in Guantanamo. Maybe approximately 40 individuals are held at the Guantanamo facility these days. Now that's down considerably from the sort of 1,100 or so that were originally incarcerated in Guantanamo. But there are still some that are continued to be incarcerated in the Guantanamo Bay facility. The United States government has considered over time, a number of times, closing Guantanamo, doing something about the remaining detainees there. There obviously are various possibilities. Ship them to foreign countries, although most countries do not want their own nationals back, people who are in Guantanamo. They can be brought to trial in U.S. courts, and some have been, or they can be held in continued detention or in some other manner. The key question is what to do with the incorrigible, really hardcore terrorists. Some of those few remaining in Guantanamo have been released and re-released and have immediately gone out to the battlefield or gone out and committed acts of terrorism and killed more victims or created more destruction. What do you do with the repeat offenders? This is a consideration for the U.S. government, and as far as I know, there's no final decision. There still are, the facility is still open, and there's still discussion about it.